Hello and welcome to AC's webinar on professional appointment contracts. My name is Wendy Lesebiken. I'm the Director of Compliance and HR at ACE, and I am delighted to introduce our two presenters for this afternoon's webinar, Andrew Croft of Beale & Co.
Hello.
And Henry Pipe of Max Fordham LLP.
Hello.
We anticipate that we will have about 40 minutes of presentation this afternoon, followed by questions and answers. Please do submit your questions throughout the presentation as soon as you can think of them, and we will answer as many as we can when the main presentation is finished. We want an interactive session today, so please do join in by sending in your questions. Before we get started, here are a few ground rules to help the webinar run smoothly. Please mute your microphone if you can. You will see some instructions on the slide in front of you, which tell you how to submit your questions. Please send your questions to us by choosing the Send Privately option. If we don't have time to answer all your questions today, we will ask our presenters to provide answers, which we will circulate after the presentation. We will also circulate a copy of the webinar and a copy of AC's Good Practice Guide.
Thank you, Wendy. The ACE's Legal and Commercial Group has seen a trend over the last few years. Contractual terms are getting more onerous, while clients are expecting consultants to take on more and more liability, and fee levels remain under pressure.
Thank you, Henry. Yes, there has been a real rise in the more onerous terms being imposed in the last few years across the market, and we have certainly seen a rise in claims against consultants. This is often simply because the consultant is one of the main parties on a project that has a robust professional indemnity insurance cover, and therefore it can become the focus for a claim. Because of this hardening market, it is really key that all consultants have a clear approach to risk management. And a key way to manage these risks is to have a clear contract in place on any particular project. And just as an example of bad risk management in practice and why risk management is really important, one recent case really highlighted this issue. Essentially, the consultant had agreed a fee of around £9,000 in relation to its services. Unfortunately, the consultant forgot to send over its standard terms to the client and therefore had no written contract in place, and therefore no limit of liability. Although the consultant's fee was, as I said, only £9,000, ultimately issues arose causing losses being claimed by the client of up to £100 million. This is a very extreme example, but because the consultant didn't have a limit of liability, because it didn't have a written contract in place, this was a significant risk, and if it had entered into a contract, it would have been able to limit this risk to a much more manageable amount. So, this underlines why it is important to have a contract in place on any commission, whatever the value is.
And having a contract in place doesn't necessarily mean having a signed document, does it?
No, that's right. Contracts can be verbal, or it could be formed by an exchange of letters or emails, or it could be a set of standard terms and conditions which are put up on somebody's website or attached to an email, for example. If the correspondence shows that you have an agreement in place in relation to the key points, then there may well be a binding contract. A contract requires one party's offer to be accepted by the other parties. Sometimes this acceptance can be inferred by conduct, for example, by one party not responding to a proposal, but essentially getting on with the project. For example, if a consultant submits a fee proposal and then the client instructs the consultant to proceed on the basis of that fee proposal, the fee proposal may well form a contract. Alternatively, if the client sought to impose its own terms and conditions when accepting the consultant's fee proposal, and the consultant carried on without objecting to those terms, the consultant may well find that it has accepted those terms and conditions by proceeding with the services. This underlines that it is really important that a consultant responds to any proposal received from the client which refers to terms and conditions and considers that proposal carefully.
So if you ignore a set of proposed terms and conditions, you might find that you have inadvertently accepted them. In our industry, it seems very common that consultants start work where there isn't this sort of agreement that you've just described, Andrew, and the contracts end up being agreed much later on in the project. What is the real risk with this?
In my view, there are two key areas of risk. Firstly, the consultant's entitlement to payment in those circumstances will be unclear. And secondly, the consultant's liability may well be unlimited. This is because the way contracts work, essentially nothing will be agreed until everything, or the really key aspects of the contract, have been agreed. So simply having a discussion in relation to a project where you submit a fee proposal which only covers the amount of the fee, for example, won't mean that you've got limits of liability in place.
I think that's a really good point. But contracts aren't just there for when things go wrong, are they? I come across situations where consultants are worried about enforcing things that are in the contract because they don't want to be seen to be getting contractual. That's a perfectly natural view to take, but I think there's another way of looking at it. A contract negotiation is an opportunity for all the parties to talk openly about how risks on a project should be allocated between them, and they can then agree in advance how any difficulties or problems should be handled if they arise. Things they might consider are what happens if the consultant is negligent and causes loss to their client? What happens if the client is late in paying? What happens if changes or delays by other people cause extra work for the consultant? It is always so much easier to agree what to do in these situations at the outset of the project than it is once things have started to go wrong. And if you agree what you're going to do at the outset of the project, and then you've written it down so all the parties are clear, then you shouldn't worry about doing the thing that you always said you were going to do if that situation arises. It isn't really getting contractual, it's just doing what you agreed you were going to do. And you should fully expect the other party to enforce the terms of the contract too.
I completely agree, Henry. And in fact, there are a number of clients out there who will in fact respect the consultant a lot more if they make proper use of the contractual mechanisms. They see it as respecting the agreement that you have reached at the start of a project. And in fact, some clients will not take action unless those contractual mechanisms are used. For example, I know that a contractor wouldn't be afraid of being contractual under a building contract. There are also a number of contracts and appointments where if the consultant doesn't use the contract throughout the course of the services and take advantage of the mechanisms, the consultant may well lose its entitlement or be exposed to additional liability. For example, a number of bespoke appointments, which are not on standard forms, will say that the consultant will not be entitled to any additional fee unless the amount of the additional fee has been agreed with the client before the additional services were commenced. So if you just kept that contract in the drawer in those circumstances and didn't seek to agree the additional fee, the consultant would be tied to the additional fee even though it had performed additional services. Another perhaps extreme example of a very administrative contract would be the NEC suite of contracts, which require, amongst other things, regular early warning notices to be given and regular programs to be updated by the consultant. In addition, the consultant is required to notify compensation events within 8 weeks of them arising, and if it fails to do so, will lose its entitlement to additional payment or to an extension of time. So it really is important under any contract that the contract doesn't just sit in the drawer throughout the course of the project and that the contract is actively managed.
And that's why it's important that the people you have running a project know what the contract requires. We've talked a bit about what the contract is and why you should have one, but we should talk about the things that a contract should say. So Andrew, what would you say is the most important thing that a consultant should get right in their contract?
Easily the most important thing for any consultant is to have a limit of liability in any appointment. We would recommend a financial cap on liability, which sets a maximum amount that the client can claim against the consultant under the contract. And there's an example of that sort of clause in the slides, which will be circulated after this webinar. Without a limit of liability expressly stated in the contract, the consultant's liability will be unlimited. The consequences of that will be that unless the consultant has significant assets to cover all of its liabilities, particularly liability in excess of its professional indemnity insurance arrangements, any claim that is greater than its professional indemnity insurance level could result in the consultant going out of business. So, this is a really important point.
What should I be looking for in my contract to make sure I have this cap on liability?
Essentially, any cap on liability will expressly state that the consultant's liability under the appointment is limited to a specified amount or figure, as shown by the example on the slide. An obligation to maintain professional indemnity insurance, for example, is not the same as a limit of liability, and that's a fairly common and understandable thing to confuse. An obligation to maintain professional indemnity insurance is simply what it says on the tin, an obligation to take out that insurance. To have a limit of liability in a contract, you need an express statement that the consultant's liability will be limited to a specified amount.
So the key point is for consultants to make sure that their contract says that the liability is limited to a fixed amount, which should be an amount that they can afford or they're insured for, and they should not confuse this limit with any separate obligation in the contract to have insurance.
Yes, that's exactly the right approach. We do see some clients that are reluctant to accept financial limits on liability, and I would say, based on experience, it is quite rare for a bespoke appointment, which isn't in a standard form, which has been drafted by the client, to include a cap on liability at the outset. However, all consultants should think very carefully before agreeing to any appointment that doesn't contain a limit of liability. And generally, and again from experience, the majority of clients will be prepared to agree to limits of liability, with some exceptions, once you've explained the importance of limits of liability to the client and you've discussed it with them. The key point to make to the client is that if you don't have assets to cover a potential claim, a claim above the amount of your insurance limit could put you out of business, which is not in your interests and also not in the client's interests.
That's absolutely right, and that's a really useful point to make when negotiating your contract. Some clients do question why they should include these limits. After all, they're paying a professional consultant, and they want the consultant to be liable for the consequences of their own negligence. But clients should remember that having no limit of liability does not mean that they have access to limitless funds. Consultants rely on their insurance, and so large claims above this amount will put most consultants out of business. If a consultant goes out of business, they won't be able to maintain insurance, and so if there are problems on other projects for other clients, those clients will find themselves out of pocket too. A cap on liability gives clients certainty and confidence, which they won't have otherwise.
Exactly, and that feeds into the reason why the majority of appointments will include express obligations to maintain a specified level of professional indemnity insurance. This enables the client and the consultant to agree how much cover they think is appropriate, given the nature of the project and the risks involved, and to make sure that the consultant is able to cover the risk with that insurance and continues to do so for a specified period of time. But this arrangement will only work if the consultant is still in business. If the client insists on unlimited liability, they run the risk of the consultant becoming insolvent, and then the client being unable to recoup that if there is an issue.
It's worth pointing out that it's not just us who are saying this. The government's Crown Commercial Service produced a policy note for public bodies, which encourages them to avoid onerous provisions. One of its recommendations is to avoid unlimited liability provisions unless these are required by law or can be clearly justified commercially. This puts the onus on public bodies to justify them, and it is always worth raising this in a negotiation. The document is available online and there's a reference to it in the slides.
Another key area that consultants should think about when they're considering the liabilities under any appointment is the extent to which they are liable for indirect and consequential losses. Consultants are typically liable for losses directly arising out of their negligence. There is also a risk that a consultant could be liable for indirect and consequential losses, which could be far removed from the services being provided by the consultant. These losses could be significant and can be very difficult to predict at the outset of the project. So, if there is no exclusion for indirect or consequential losses at the outset, it will be very difficult for the consultant to assess the extent of risk that it is assuming under any particular appointment.
So a consultant might end up facing a claim which is many times bigger than just the direct costs of remedying the problem.
Yes, that is exactly the point. For example, if a consultant was appointed to design a fairly low-value residential property, the losses of any physical damage arising from any errors in the consultant's design may be fairly limited. However, the client's indirect loss, for example, if it was unable to receive any rental income as a result of the issues, could be very significant, and that underlines the importance of trying to limit or exclude any indirect or consequential loss where possible, as shown by the example on the slide.
What else should consultants be looking out for to understand and manage their liabilities?
Another key point, which I would call a red flag to look out for in any appointment, is an indemnity.
What's an indemnity?
In normal circumstances, a client making a claim against a consultant will have to show that the consultant has been negligent or has breached the contract in some other way and has caused the client to suffer a loss. The client will then be expected to take reasonable steps to mitigate their losses, and the claim against the consultant will be reduced if the client themselves have been negligent. However, an indemnity is essentially a promise to pay for a specified type of loss, regardless of the reason. So in some cases, the consultant would be required to pay even if they're not at fault. In addition, an indemnity essentially entitles the indemnified party to recover all losses suffered on a pound-for-pound basis in connection with the matter that has been indemnified. So, the losses recoverable would not be subject to the client taking reasonable steps to mitigate those losses, for example.
So let's say I designed a building which my client is now leasing out to tenants, and one of the tenants brings a claim against my client which relates to my design. Now, normally my client would be able to claim against me if I had been negligent in my design or had breached my contract and that this had caused the loss. If I could show that neither of those were true, then I would be able to defend the claim. But if my contract provides an indemnity to my client, which covered claims brought by third parties arising out of the performance of my services, then things are quite different. The client can just settle the claim by paying the third party and then claim this amount from me through the indemnity. They don't need to show that I've breached my contract so that I can't defend myself, and I'm liable for the loss even if I've done nothing wrong.
That's exactly right, and underlines why it is so important for consultants to avoid indemnities, in particular if the consultant could be liable when it hasn't been negligent or is not in breach of contract. There is a risk that the consultant's liability under such an indemnity may not be covered by the consultant's professional indemnity insurance policy. So the scope of any indemnity should be considered very carefully, and the preferred position would be to delete any indemnities where possible. Only in areas which are clearly within the consultant's control and when an indemnity cannot be resisted should indemnities be agreed by a consultant. And even in those limited circumstances, the indemnity should be limited as much as possible. For example, the losses recoverable should be those directly arising from the consultant's negligence, and the losses should be reasonably foreseeable and must have been fully mitigated before the consultant is liable for them. Now, how do you spot an indemnity? Often, it will be quite straightforward. For example, it will use the term indemnity or indemnify, or it will require the consultant to hold the client harmless for a range of losses. However, There are indemnities, often drafted by lawyers who are trying to be a bit clever, which are included in appointments which are not as easy to spot. And they may simply require the consultant to reimburse the client in relation to certain losses, for example. A very topical example of that would be the indemnity in the NEC 4 professional services contract, which was published in June last year, which requires the consultant to reimburse the client for losses in relation to a matter for which the consultant is at risk. So, the key thing in relation to indemnities is to consider any clause which requires the consultant to reimburse the client for any losses or indemnify the client very carefully and resist them if possible.
Can we talk a bit about joint and several liability now? I understand that if more than one party has contributed to a loss, then a client can claim the full amount of the loss from any one of them. What does this mean in practice?
That's right. In practice, this means that if there was an issue that was caused by more than one member of the project team, any claim could be made against both the consultant and the other members of the project team. Or the client could choose to make the full claim against just one consultant. In these circumstances, that consultant would normally have a right to recover a contribution from the other parties who caused the loss under the Civil Liabilities Contributions Act. But there is no guarantee that the consultant would actually be able to receive that money. For example, the consultant will incur irrecoverable legal costs in bringing those contribution claims, and in addition, the third party may not have sufficient assets or insurance, or it may become insolvent between the breach occurring and the claim being made. It is for these reasons that net contribution clause is really important. There is an example of a net contribution clause in the slides.
As you say, this is especially a problem if the party which was significantly at fault is no longer around, and there have been cases over the years following contractor insolvencies where consultants and their insurers have been left with very large claims. The consultant may have only had a very small inspection role, but could find themselves paying the price of the contractor's failure if the contractor is no longer around. As it is the client who selects and appoints the other parties, they are the ones in the best position to manage the risk of insolvency of the contractor or of someone else on the project, and so a net contribution clause seems a fair and reasonable allocation of the risk.
While we are discussing the consultant's liability, we should remember that it's not just the amount and types of liability that should be restricted, but also the time in which claims can be brought. As shown on the slide, the liability periods under a contract will depend on whether the contract is entered into what's called underhand, by being a simple contract, or whether it's a more formal deed. Liability under a simple contract will continue for 6 years, whereas under a deed, it continues for 6 years. In addition, liability outside the contract in tort can continue for up to 15 years. This all underlines the importance of trying to have a specified limitation liability period in any contract. And if possible, that should be tied to when the consultant last performs the services, rather than, for example, being 12 years from practical completion of the project, which is a common requirement. The concern with that sort of arrangement is that the consultant may complete the performance of the services far in advance of practical completion, so that could in fact extend the consultant's liability.
Now, we've mentioned the consultant's duties a few times and also mentioned negligence. Andrew, can you explain what these mean and how they relate to the consultant's contract?
Yes, to put it as simply as possible, a consultant will owe a duty of care to their client, which sets a standard to which the consultant is required to carry out their work, and that duty will apply whether or not there's a contract in place. Over the years, the courts have developed a legal basis for assessing this duty of care, and it requires the consultant to exercise reasonable skill and care. This is often referred to as the common law duty of care. A failure to exercise this reasonable skill and care is what is referred to as negligence. Commonly, contracts will also set out a specified duty of care, and as we'll mention shortly, this should be as close to the common law duty of care as possible. There are a number of different approaches to duty of care in appointments, and many forms of appointment, particularly bespoke appointments, will seek to place the consultant under a much higher standard than the common law duty of care. This might be by including words like all before reasonable, by requiring the consultant to exercise the reasonable skill and care of an expert consultant, or perhaps by not including reasonable in the duty of care at all. One of the reasons this is so important is that traditionally a number of professional indemnity insurance policies would operate on a negligence-only basis. So if your duty of care is higher than a common law duty of care, that may be inconsistent with your insurance arrangements.
And this is all different from fitness for purpose, isn't it?
Yes, fitness for purpose is a slightly different beast. Fitness for purpose is typically something which is imposed on contractors because it relates to the quality of the finished product as it is constructed rather than the design. They, for example, will have an obligation to ensure that the works, when complete, will be fit for purpose. That's often reasonable because a contractor will have control over the end product of the works, as it often both designs and constructs them. However, a consultant will generally only be involved on the design side, and it cannot guarantee the outcome of a project. The key concern about fitness for purpose is that the majority of professional indemnity insurance policies will include express exclusions for fitness for purpose. So, if a consultant accepts fitness for purpose obligations, they will be exposing themselves to liability, which is not covered by their professional indemnity insurance policy. Now, a fitness for purpose obligation can arise in a number of different guises. It may be as clear as a statement that the consultant will ensure that the works, when completed, are fit for purpose. But more commonly, it will be less obvious than that. For example, the consultant may be required to ensure that the completed project achieves specified performance levels, for example, and even that could give rise to fitness for purpose because the consultant cannot guarantee that specified outcome.
And so it's really important to check the contract carefully and remove any fitness for purpose obligations. But it's not just the appointment document itself which you'll need to check, as sometimes fitness for purpose requirements can be included in the schedule of services. Andrew, if the schedule of services isn't yet available or it's still subject to change, is there a way of providing some additional protection within the appointment?
Yes, Henry. One approach, which is an approach that we do recommend whenever possible in an appointment, would be to include an explicit statement in your duty of care, perhaps, that the consultant will have no greater obligation under the appointment than to exercise reasonable skill and care, notwithstanding any other provision of the appointment. The reason why this express obligation is needed is because often just having a statement that you will exercise reasonable skill and care will not be enough to override a separate, stronger obligation in the appointment.
There was a court case recently, wasn't there, where the court decided that the consultant was both under an obligation to exercise reasonable skill and care, but also had a fitness for purpose obligation at the same time?
Yes, in the recent case of MT Højgaard and E.ON, this was exactly the position. There was essentially a contract which included an obligation to exercise reasonable skill and care, and also a separate express fitness for purpose obligation. The consultant complied with specified standards, but it turned out that there were errors in those standards. Even though the consultant exercised reasonable skill and care and complied with that standard, the courts held that it was still in breach of contract because of issues with the works that arose because it had failed to ensure the works were fit for purpose, essentially. This is a good illustration of the issues that can arise from signing up to both a fitness for purpose obligation and a reasonable skill and care obligation.
And as Andrew said, Your professional indemnity insurance might not cover you for these fitness for purpose obligations, so it really is worth checking the contract very carefully. And you can ask your insurance broker if you're not sure.
Another important sort of obligation which consultants should look out for in their appointment is a strict obligation. Essentially, these would expose the consultant to liability for breach of contract as soon as they fail to comply with that provision. For example, liability could arise even if the consultant has exercised its duty of care and has not been negligent. One of the traditional risks of strict obligations is that a number of professional indemnity insurance policies, as we've mentioned previously, will only cover a consultant to the extent to which they've been negligent, and so any strict obligation could expose a consultant to greater liability than is covered by its insurance. In addition, there's also the practical risk that strict obligations may be very difficult to comply with, or may in fact be unachievable. For example, an obligation to comply with a program or to comply with specific timescales may not be achievable because the consultant may be delayed by circumstances outside its control. But a strict obligation may still apply even in those circumstances. Other common strict obligations that we often see would be a requirement to comply with the third-party agreements that have been entered into by the client, for example, or to ensure that the works actually comply with or achieve planning permission.
So if my contract says that the consultant shall comply with the programme, then I'm liable for a delay even if I worked diligently but was delayed by other members of the design team. What would you recommend that consultants do in this case?
There are a few different approaches that can be taken to strict obligations. A common approach would be essentially to qualify the strict obligation by reference to the duty of care in the appointment, such that it is clear that the consultant will only be liable for failure to comply with the strict obligation to the extent that it has been negligent. And there are some examples on the slide. Another common approach would be to water down a strict obligation so that while the consultant would be required to comply with the programme, the consultant must only use reasonable endeavours, for example, to do so. There are other ways that are often proposed by clients to make strict obligations seem more attractive rather than using terms like reasonable endeavours. For example, the client may suggest it uses best endeavours or all reasonable endeavours in the strict obligation. These are both potentially onerous obligations, even though they appear to be slightly more acceptable than a strict obligation. This is because recent case law has held that both best endeavours and all reasonable endeavours obligations can require a consultant to act against its best commercial interests in order to comply with the obligation. And so this could be inconsistent with the common law position, for example. For this reason, where possible, best endeavours or all reasonable endeavours should be avoided.
Thank you, Andrew. That's been a brief overview of the consultant's obligations and some things to look out for in contracts. If you have any questions on this that you'd like us to answer at the end of the webinar, please do send them in now. Now we're going to look at some other issues you should be aware of when you're negotiating your contract. And first, we're going to talk about novation.
Thank you, Henry. Novation is essentially trying to transfer one contract from one client to a new client. This is often included or provided for in design and build contracts, whereby the consultant will transfer from the original client, who it provides the initial design for, to the contractor once they have been appointed. This is to reflect the fact that the contractor is often assuming full design responsibility under the building contract, which includes responsibility for design before the building contract was entered into. Novation essentially involves termination of the original contract and the creation of a new contract between the consultant and the contractor. It also often clarifies who has rights to bring claims and what the position is in relation to fees.
We could do an entire webinar on novation, and we're in the process of producing a good practice guide on this subject, and that should be published in the next couple of weeks. But what's the key thing that consultants should look out for in their appointment, Andrew?
The first point to always look out for in respect of novation is whether there is a requirement in the appointment for the consultant to be novated in the first place, or indeed whether there is a limit on novation. If the consultant is required to be novated, then they should make sure that they are happy with the form of novation agreement before they enter into the appointment. And that form of novation agreement should be attached to the appointment, as it may not be possible to either agree the form of novation or make changes to it at a later date. The consultant should also inquire as to who the appointment will be novated to, and ask that they have some control over who that will be. For example, a common approach would be to make the agreement to novation essentially subject to the consultant's consent, which cannot be unreasonably withheld. The risk would be that if the consultant isn't able to object to the novation, they could be transferred to a new client who either has limited resources or who the consultant has, for example, a difficult track record of working for. So, this is why it's very important to think carefully about novation in any circumstances when entering into an appointment. Just as a final practical point in relation to novation can have quite a significant impact on the consultant's fees. Often, it becomes a lot more difficult to recover fees following novation because there's no longer a long-term relationship with the client after novation, which there was with the original client. So, if novation is anticipated at the outset of a project, the consultant should try and reflect that in the fee structure, if possible. Now, there are a few different types of novation, which I'll summarize generally. One particular risky type of novation is referred to as ab initio novation, which essentially has the effect that the consultant will be deemed to have always been appointed by the contractor from the outset of the project. This ignores the fact that the consultant was actually appointed by the client for the first portion of the services, and in providing those services was acting in the best interest of that client and on their instructions, not on the instructions of the contractor. Ab initio novation is therefore a legal fiction and typically can give rise to conflicts of interest because the interests of the contractor and the employer are very different. This type of novation can therefore lead to additional claims, particularly where the consultant advises in relation to documents that have been included in the employer's requirements or the tender documents, for example. The contractor may then use these documents to price the works and be unable to recover as much money under the building contract as it had anticipated, and therefore bring a claim against the consultant following novation. There is another type of novation which is preferable to ab initio novation, and that is often referred to as switch. Essentially, it provides a much cleaner break between the consultant's obligation to the original client and the consultant's obligations to the contractor, then ab initio novation. This is the approach taken by the CIC form of novation, and that is a much preferable form of novation. If a client does insist on novation, the client should consider referring to that form if possible. Indeed, if novation is anticipated at the start of a project, or if an obligation is included in an appointment in relation to novation, it is very important that the consultant queries with the client when that novation will take place and whether it is actually anticipated. A general obligation to novate should be resisted. If ab initio novation cannot be avoided, consultants should make sure that the novation agreement is very clear that the consultant cannot be liable for acting in its original client's interests.
There is something else that consultants should be mindful of, which I've seen a few times when it comes to novation. It's very common to start work without a contract. Ideally, we'd have one in place at the start of the project, but often consultants start work and the contract gets sorted out later. And Andrew has explained the risks of doing that, not having the benefit of any limit of liability and the payment risks that might come about. But there's an additional issue with novation. Since you are already working for one client, the formal novation agreement doesn't just create a new contract with the new client, it also ends your obligation to your old client. So if you act as if novation has taken place, but the formal novation agreement is not yet in place, then you may well find that you've taken on obligations to your new client, but you still have the same obligations to your old client in parallel. As Andrew has explained, this can create all sorts of conflicts of interests and can make any claim very complicated and expensive to deal with, and so it is best avoided.
Another issue that can arise on novation is that often following novation, or at the same time as novation, the consultant is required to provide a collateral warranty to their original client in relation to the services to be performed for the contractor following novation. So that leads us on to collateral warranties themselves and third-party rights. Consultants generally will owe a duty of care to the client and will be liable to the client under the appointment. But it's not just the client who may suffer a loss and want to bring a claim against the consultant for a breach of the appointment. Collateral warranties are therefore required because they are essentially an agreement between the consultant and a third party who is not the client, which allow them to make such a claim. A collateral warranty will often include a warranty or a promise that the consultant has complied with the appointment in performing the services. As collateral warranties give a third party a right to recover against the consultant in circumstances where they may not otherwise have had that right, they will expose the consultant to additional potential liability. A similar arrangement to collateral warranties, which is often included in contracts, is a right to grant similar rights under the Contracts Rights of Third Parties Act to certain third parties. The key things to bear in mind in relation to collateral warranties or third-party rights are to try and limit the extent to which they are required under any contract insofar as possible. That might be by, if you know that either collateral warranties or third-party rights are required, including an express aggregate limit in the appointment on the number of collateral warranties or third-party rights that have to be provided, or by clearly limiting the type of beneficiary to whom they must be provided to, for example, to first tenants and first purchasers. The form of collateral warranty is also very important, and you should make sure that the form of collateral warranty doesn't expose you to greater liability to the beneficiary than you have to the client. You should also make sure that there is a clear limit of liability in the warranty, or a clear statement that the limitations in your appointment apply. If you're going to agree to collateral warranties being provided or third-party rights, the form should be clearly set out in the appointment. And it is always sensible to discuss the form of any collateral warranty with your insurers, because there will often be specific insurance coverage points in relation to collateral warranties.
We've covered a lot of issues today and want to leave some time for your questions. These issues and more are also explained in the ACE's new Good Practice Guide, which we will circulate after this webinar. But we do have time for one last issue that consultants should be thinking about before we move on to your questions, and that is liquidated damages, which are sometimes referred to as liquidated and ascertained damages, or LADs.
Yes, liquidated damages are something that is often included in the building contract, whereby the contractor is required to pay a specified amount if they fail to complete the work by the completion date. They are less common, thankfully, in consultants' appointments, but we do see them sometimes. For example, as indicated in the slide, they are an option under the NEC suite, and they're also common in jurisdictions outside the UK, or more common than they are in this country anyway. The key risk with liquidated damages is that they are often excluded by professional indemnity insurance policies, or the full amount of liquidated damages would not be recoverable by the professional indemnity insurance policy. For example, if the liquidated damages expose the consultant to additional liabilities to that which they would have without the liquidated damages, the professional indemnity insurance cover may not reimburse the consultant. Any obligation to pay liquidated damages should therefore be resisted, and in our review, they are inappropriate in a consultancy appointment.
Thank you, Andrew. That's given an overview of just some of the issues that arise regularly in professional appointment contracts, and these are all included in the Good Practice Guide. This guide is the first in a series, so keep an eye out for the additional guides which will be coming out over the coming months. And if there are areas that you think the ACE should cover in this series, do let us know. The ACE also provides a telephone advice line for free advice on general legal issues, and the details are included in the slides.
If I can just say, we assist with the legal advice line, and I would just say it is a very useful service, and it entitles you to 20 to 30 minutes of free advice on any particular contractual or legal issue. So it's certainly worth considering if you just want to sense check a particular point.
Of course, if you have questions on a specific appointment beyond that 20 or 30 minutes advice, you can always get legal advice from Andrew or from another lawyer familiar with consultants' contracts in the construction industry. And last but not by any means least, many insurance brokers, including all of the brokers on the ACE panel, will provide a contract review service for you too. That leads us on to your questions, and we've got a few questions that have come in during the course of the webinar. We'll reply to them to as many as we can. Perhaps we'll start with, there have been a few questions on limits of liability. So there's a question here, how should I set the cap on liability? And someone else has asked about whether the limit of liability is supposed to be 10 times the fee. Andrew, is that something that you can talk to?
Yes, and I guess firstly, the test for reasonableness is a fairly complex one under the applicable legislation. But the general rule of thumb that we would approach is that when considering whether a cap is reasonable, you look at the assets that are available or the extent to which available to the parties to cover a certain risk and the rest of the agreement. And a key principle that we normally adopt is therefore that any limit of liability which is consistent with the professional indemnity insurance requirement under a contract will be reasonable or is very likely to be reasonable. So I think that should always be the starting point in deciding where to pitch your limits of liability. If in addition there are particular significant risk under an appointment which you're not prepared to take, that may be justification for including a lower limit of liability.
And of course, the insurance level is a good place to start because you've had to get into a negotiation with the client or they've asked for a particular level of insurance. And I think we're seeing those levels start to increase. We're starting to see requests for £20 million insurance, and for many consultants and on many projects that won't seem reasonable. But if the client is saying, I want this much insurance and you don't think it's reasonable, it's a very good opportunity to have an open conversation with the client about what the risks on that project might be. For example, it might be that the client has an awareness of something that might give rise to some consequential losses that you're not aware of. By having that open conversation at the start of the project, you can agree between you what a reasonable level of insurance and a reasonable limit of liability cap might be.
And I think just one further point, generally recent case law has indicated that courts are taking a more commercial approach to limits of liability than they used to, say, 10 years ago. So generally, if you could demonstrate that a limit of liability was agreed commercially between two parties of fairly equal bargaining power, it would indicate that there's less risk of it being challenged for being unreasonable. But as we've both said, the level of insurance is always a very good starting point.
There's a question that's come in that follows up on one of those issues to do with reasonableness. It says, can you please address whether and how reasonableness principle may apply to consultant appointments? This might be relevant to a small consultant without routine access to legal advice. So when we talk about reasonableness, what do we mean in practice?
And I think it is generally under the Unfair Contracts Terms Act, if a term is unreasonable, it would be unenforceable, and that generally involved looking at the ability of the two different parties to address that risk. And I guess if the consultant has limited assets, for example, and a low level of professional indemnity insurance, that would justify a lower limit of liability being more reasonable.
We've got a question about payment of fees. Can my client say that I will not be paid until they get paid?
And yeah, that is unfortunately, it's something that we are still seeing in some appointments at the moment. Essentially, that sort of term, which is called a pay when paid term, would be unenforceable under the Construction Act. And so, although your client might include that in the appointment, they wouldn't be able to rely on it. Nevertheless, it's a sort of term that should always be resisted where possible, because you should be entitled to be paid based on your services, not based on your client's performance under a separate contract.
And so when we're relying on the Construction Act rather than a provision in our own contract, it's important to remember that that applies to construction operations within Britain, isn't it? So if you're doing perhaps a piece of feasibility work that is long before and not particularly anticipating construction work, you might not find that it's covered. Or if it's an overseas project, that won't apply either.
No, exactly. And I think from experience in the UAE, pay when paid is unfortunately very common out there.
We've got a question following up on the Hurgard versus E.ON case. There's a question, what are your views on the implications of Hurgard versus E.ON? Whilst discussing appointments with a number of solicitors, they have stated this is not relevant, which the questioner disagrees with, and thinks that it's a risk to many consultants. So what are your thoughts, Andrew?
I would certainly agree that it does suggest additional risks for consultants, as we discussed in the webinar. I think there's a few areas. It identifies the risks that can arise from agreeing to two different types of obligation, i.e. having a duty of care and then a separate, more onerous provision, which could be inconsistent with your professional indemnity insurance policy. And secondly, it identified the risk of those sort of obligations being hidden in your scope of services, for example, because in the MT Hurgard and E.ON case, the key contractual requirement was hidden in one of the appendices. So it really underlined, from my perspective, the importance of seeking an overriding duty of care in any appointment, which expressly states that the consultant's only obligation is to exercise reasonable skill and care.
There's a question here on a slightly different subject. Do I need a contract if I'm appointing sub-consultants?
Yes, and I think that is a good question, and I think it's an area that is often overlooked by consultants on a project. You do need a contract if you're appointing sub-consultants, essentially so that you can manage the risk that you're taking on under your appointment by taking on responsibility for that sub-consultant services and pass them down to the sub-consultant, essentially. If you don't have that sub-consultant appointment, your rights to recover from the sub-consultant would be unclear and may not be consistent with your liability under the main appointment.
There's another question on caps on liability that has come in. When discussing the limit of liability, clients sometimes argue that if they can't recover any more from the consultants than their amount of their PI, then they don't see the point in introducing a financial cap. because they don't care whether or not a claim puts the consultant out of business. What would be a helpful counter-argument to that? Well, that's one that I'll try to answer. I think clients need to understand the way in which PI insurance works, which is on a claims-made basis. So that means that even if the work was done 4 or 5 years ago and you were paying for your insurance 4 or 5 years ago, it's the insurance that you are paying for now that will cover a claim that arises now. And if you are employing a consultant who, to put it bluntly, is prepared to gamble their business on every single contract that comes along if they are routinely accepting unlimited liability, then you really do run the risk that if there is a problem on your project, that consultant is no longer around and is no longer maintaining insurance. So the counter argument that I would make to clients in those circumstances is that if you are requiring the consultant to carry insurance, you also need the consultant to have a good risk mitigation in place in the way they run their own business to make sure that that insurance is available if and when you need to bring a claim. And if the consultant is routinely entering into contracts that carry unlimited liability and potentially jeopardize their business, then that insurance may not be there when you come to call on it.
Yes, I would agree. And I guess one other point to make might be that you're trying to seek a long-term relationship with a particular client, and if, because you've got no limit of liability, there's a risk of you becoming insolvent straight after one appointment. It doesn't really give you that confidence.
I think we've got time for a final question. There have been quite a few come through, and so we'll attempt to answer some others that have come through and share those in the notes that we send around following this. But a final question on the sort of the approach to negotiation. How do you deal with a situation where the procurement process doesn't allow any changes to be made to the contract terms?
Yes, I think that's something that we're seeing quite commonly on public sector contracts. It seems that increasingly the form of procurement is one where negotiations cannot be entered into by the local authority. Essentially, in those circumstances, from our perspective, the key steps are to try and understand what levers you have as part of the procurement process. So, for example, submit requests for clarification to understand the extent of your risk to some extent, and also to have a good understanding of who the client is, because some of them, even though they would be operating outside the public contracts regulations, they will still enter into some discussions after the tender process has come to an end.
But ultimately, if you're signing up to something that says there is no opportunity to negotiate and this will form a contract, then it is a commercial risk, and you need to take a commercial view whether or not you want to proceed with that tender submission.
Yes, that's exactly it. You can't rely on, and possibly they may negotiate and almost cross your fingers.
Well, thank you very much, Andrew. I think we've got through a good number of questions there, and as I say, there are others that we will attempt to answer and circulate answers with the notes. We've just put a summary of the key points that we've covered up there for you as a summary, and we will circulate the slides, a copy of this presentation, and the new good practice guide following this webinar. Thank you very much for taking the time to join us today. I hope that you found it useful and interesting. If you have any feedback for us or any ideas for future guidance and future webinars, we'd be very interested to hear about that too. But thank you very much.
Thank you.